Yeah, he lost it. He started going crazy. Pointed his finger, slapped the table a bunch, started crying. I remember him losing his stuff, and I remember them going back in chambers. I remember.
Doing so, but I asked Mr. Scalia to sit down and shut up.
Your Honor, really, Mr. Willig, this is really completely unprofessional. This is...
Stop!
Good afternoon, everybody. I will call this meeting of the Senate Judiciary Committee to order. That takes us to SB432.
Final bill on your work session is SB432. It revises provisions related to privacy and was sponsored by the Senate Committee on Judiciary. It establishes that family law proceedings are presumptively open unless an exception applies, and authorizes a court to exercise its discretion and close any such proceeding if the court determines that the closure is necessary to serve a compelling interest. The bill also makes an unlawful act punishable as a Cat C felony for willfully and intentionally posting or displaying any public manner certain personal information of another person without the consent of the person. And we do have one amendment proposed on this measure. Chair Scheibel proposes to amend the bill to change the penalty from a Category C felony to a Category D felony. Thank you, Chair.
Thank you. Any questions on SB 432? All right, not seeing any.
I would just like everybody else, Madam Chair, I just wanted to let folk know that I will be voting for it to move out. A lot of folk have been reaching out with many concerns, and I may switch my vote on the floor. Thank you.
Alex here. So this is a really good sign. What this means is the members of the committee have been getting your messages, whether it's phone calls, letters, or post the opinion on Nellis. By the way, the opinion, it looks to indicate that it is now 92% opposed, 7% in favor. So those of you who are going into Nellis and putting those opinions in are making a difference. It's good to see that these legislators are concerned enough that even though they're going to let it through committee, that they may change their vote on the floor and reject it. But it definitely does not mean that you guys should let up.
Hopefully this works. I would like to also reserve my right. I have some questions that came in late. I know that's not on the sponsor of the bill and the presenters, but I would like to reserve as well.
Alex here. So again, this is another member who's withholding, and it is showing that support for the bill is wavering. Melanie Scheibel, who apparently sponsored the bill, is concerned. If it's not Melanie Scheibel, it's James Orenshall. But I'm 99% sure that Mr. Orenshall sponsored it last session and that Ms. Scheibel is the one that sponsored it this session, which would make sense because as the chair of the committee, she has the most power. And to see this member saying things like, you know, it's not on you or it's not your fault, it's showing, you know, that there was some kind of understanding that is no longer being abided by based on the letters, the phone calls, and all of the, you know, all of you guys reaching out. You're making a difference such that whatever was arranged by Ms. Scheibel and these members is not as strong as it was before. So your voices are being heard. And I should also mention that this is not really, or this is something that I think, or I know that Ms. Scheibel could have avoided by reaching out to the First Amendment groups like the Press Association, the Open Government Coalition, Our Nevada Judges Incorporated. I've done this for a few sessions, I think 3 at this point, and when something gets put together that's going to impact First Amendment rights, usually whoever is sponsoring the bill will reach out ahead of time and coordinate with the First Amendment groups. They won't just sneak attack us by putting the bill up and ramming it through a committee with virtually no time for discussion. The language of this bill is convoluted and lengthy, and Ms. Scheibel's, like, I guess you could call it a band-aid by reducing it from a Category C felony to a Category D felony. It's barely a token apology to what has happened. So it's going to be interesting to see what happens when this gets to the floor, because I think at this point they've only heard sort of the initial voices in opposition. There's going to need to be, or I'm assuming there's going to be a lot more opposition going into the next week, especially when you guys see the end of this video. I'm sure you're going to be quite interested to see why I ran a clip of Mr. Willig going off the rails in front of a district court judge, Gail Nathan, that is not just an attack or a smear of Mr. Willick. That video is 100% on point and relevant to this bill, and you will get a full explanation at the end of the video, so stick with me.
Senator Orangel?
And just a ditto, same thing. I got contacted late with some concerns. I vote to move it out of committee, but reserve my right, Chair.
And as the presenter of the bill, and of course it's sponsored by the committee, and as the chair of the committee, I think it is my responsibility to follow up on this bill. I'll also be meeting with stakeholders and, working with members of the committee to try to address concerns that remain with the bill. So, Senator Ellison.
Thank you, Madam Chair. I want you to know that I was not going to reserve my rights, and I was not going to vote no. Thank you.
Okay. Well, thank you. That being the case, I would accept a motion to amend and do pass. All right. I'll second the motion from Senator Nguyen, the second from Senator Orenshaw. Any discussion on the motion? Not seeing any. All in favor say aye.
Aye.
Aye. And any opposed, nay. All right. The measure passes unanimously to amend and do pass. I will assign the floor statement to myself. And that brings us to the conclusion of our work session. And thank you all for your hard work today and always on our committee. But we're not done yet.
Alex here. Okay, as mentioned before, I'm going to go ahead and connect the dots for you guys. So before we go into the rest of the video on Marshall Willick, I actually have a couple of videos. I need to go through why it is relevant to this bill. And that involves less a discussion on Mr. Willick out of control in open court and more a discussion on sealing, confidentiality, jailing, and in this case, not even jailing, imprisonment, because I'm probably giving you guys a little hint that I am going to show you that this video that I ran for you guys, that clip in the beginning, was sealed, and that the court did threaten to jail an attorney over that video. And let's just go into it. I've got the document. I'm going to go ahead and put it up on the screen. Actually, you can already see it's up on the screen right now as I talk to you guys. So this video, or this minute order, was signed by former District Court Judge Gail Nathan. She was already voted out of office quite a while ago. But onward. So according to this judge and this minute order, two litigants in proper person, you will please take notice that review of the court file indicates that a minute order was issued on July 23rd, 2012. The court entered the minute order to be faxed and mailed to counsel immediately by Department T's JEA. Therefore, this court will prepare said paperwork as followed. It is hereby ordered that the attached copy of the minute order from July 23rd, 2012 is hereby incorporated herein and will become the order of this case. Scrolling down, you can see the actual minute order itself that the judge entered, former judge. It says, minute order regarding 6/29/12 hearing per Judge Nathan's request, the court finds that although it ordered that the proceeding from June 29, 2012 be sealed and the video not be released absent a court order, that said video has been released to attorney Joseph Scalia. The court finds that this is a clerk error. It is hereby ordered that Mr. Scalia is to return said video and any and all copies that may have been made from this proceeding to the clerk's office no later than July 24th, 2012 at 5 p.m. It is further ordered that Mr. Scalia may not keep said video in any form in his computer record. Mr. Scalia and the plaintiff are enjoined from releasing said video in any form to any third party. So you have seen the clip, and was there a baby's face? Were there kids' faces? Were there kids' names? Were there addresses? Were there phone numbers? Were there parents' names? No, there was none of that. What that video depicted was Mr. Willick out of control in open court. And it's very difficult for me to think of why that video should be sealed. Certainly, there's no First Amendment basis to. And if you read this minute order, there's no citation to the strict scrutiny analysis. It's just sealed because the judge said so. Certainly, it would have probably been embarrassing if she had included some kind of analysis in there, because she obviously wouldn't be able to cite any sensitive issues because there weren't any. It's a video of a divorce lawyer And, you know, we could give the judge the benefit of the doubt, but if we give the judge the benefit of the doubt, what we're going to do is point the finger right at the legislature. So to give this judge the benefit of the doubt, we would have to guess that she was complying with a statute that the legislature enacted, that, by the way, is currently targeted for nullification as a violation of the First Amendment, a statute that categorically seals all videos. So, yeah, perhaps the judge was following the law, but what does that say about the law, and what does that say about the competence of this legislature? Why do we have a video of an attorney acting out of control under seal? Why is that happening? So this is just, you know, I guess the first step in our analysis. Let's go to step 2 here. We have an order to show cause because sealing the video was apparently not good enough. By the way, I have no idea who's even asking for this. I've looked through the records and I can't see a request by an attorney that this video be sealed. All I can see is a judge sua sponte making orders. And either the judge on her own has decided to protect that attorney, or somehow some ex parte communications got to her asking her to do this without any request or filing. I can't find any filings. So it's either that the filings don't exist and the judge did do this sua sponte, former judge, or there's a possibility that that the requests are sealed. And if the requests are sealed and I don't have access to them and I can't give an accurate reporting, it's not my fault. That is the fault of the family court or whoever it was that sealed those records. So if there's anybody watching and they're frustrated because I'm saying that the judge did, you know, some kind of sua sponte action and she actually didn't do sua sponte action, then you need only look into the mirror, because I'm not the one that put these policies in place. So it having come to the court's attention that the court's order of July 23rd, 2012, in which Mr. Scalia was ordered to return the video from the 6/29/2012 hearing and any and all copies that may have been made from the proceeding to the clerk's office no later than July 24th, 2012 at 5 p.m., and that he was further ordered not to keep said video in any form in his computer record and was enjoined from releasing said video in any form to any third party, has not been complied with. It is hereby ordered that Joseph Scalia shall personally appear before the Clark County District Court, Family Division, Department T, on the 23rd day of August 2012 at the hour of 1:30 p.m. to show cause, if any, why he should not be held in contempt for his failure to comply with the court's order of July 23rd, 2012, and to further show cause why he should not immediately comply with said order, and to further show cause why Joseph Scalia II should not be incarcerated for an amount of time to be determined by the court for his failure to comply with said order, or fined or otherwise sanctioned in an amount to be determined by the court for its failure to comply with said order. This hearing shall be vacated upon proof that Mr. Scalia has returned said video to the clerk's office and has filed with the court a declaration that he has otherwise complied with the order of July 23rd, 2012, providing a courtesy copy to Department T chambers of said declaration prior to the scheduled hearing date. A copy of the order of July 23rd, 2012 is attached hereto and incorporated herein. This order to show cause shall be mailed to Joseph Scalia II, and a copy put in his attorney file held at or kept at the family courthouse. So it looks like they're even putting it in some kind of personnel file. So I guess this is a good time to talk about this. I have talked to stakeholders in the past and insiders about this issue of attorneys not being able to speak out because they're scared. I haven't talked about it with you guys, with the viewers, with the general public, because it sounds nuts. But here you have an example. There's a lot of people who complain to me. Why don't attorneys do the right thing? Why don't attorneys speak out? Why don't attorneys blah, blah, blah? Well, this is what happens. This attorney, I don't even know if he's the reason it got to the documentary. The documentary was not published by this attorney, the one that from the clip that I showed you guys. So for all we know, who knows how that video got out? But this still provides a really good example to you guys of what happens. A video that doesn't have any sensitive information of any children or parents whatsoever, that has been sealed. An attorney will say theoretically, sticking his neck out. And the consequences for doing so, it's not a pat on the back. It's not an award. It's not a thank you. No, it's we're going to put you in jail. So, put yourself, in the shoes of attorneys, and you want to speak out against some kind of outrageous conduct in open court. You want to speak out and you want to, do the right thing. And a judge tells you your law license is on the line for doing this, and I'm going to put you in a cell. Think about how that feels. Think about the effect that that has on attorneys and their ability to try and do the right thing. And this also, brings up something else. If family court judges are already capable of incarcerating people who release a sealed video, why do we need a statute that makes it a felony? Why does the police need to get involved? Because apparently the judges are already capable of doing this on their own. And, one of the things that is highly relevant to the discussion is that the family court cases are all wildly different. You can't paint these cases with a broad stroke. You could have some cases that that should be confidential. You could possibly have some redactions that need to occur. Who's going to be the one that makes that decision? Certainly it shouldn't be the attorneys, because if you let Mr. Willick make that decision, he's going to seal this video just because it's going to destroy his reputation. But if you put it in the hands of the parents who are under the control of the attorneys, who have virtually no power, who are going to put their own self-interest and the effect it's going to have on their case ahead of the public interest, you're not going to have a very different outcome. No offense to litigants, but the litigants are there to win their cases. The litigants don't file a lawsuit because they want to educate and inform the public. I mean, that's just silly. People go to court and file lawsuits because they want to win. And so their concern is whether or not public, access to the case is going to have an impact on their case, whether it's going to affect their lives. The person who is best equipped to consider the public interest is the judge. And so if the judges are the ones that are in the best position to decide what to seal, why is the legislature implementing statutes that would categorically make it a crime to publish these videos? And I mean, this is just divorce. Like, divorces there are statutes, as I have mentioned, that arbitrarily seal and close things. We've struck down the one that closes hearings, but the other one is still pending nullification. It's been targeted for nullification in another case. If you watched the Cody Gamble versus Leon Nestor, that would be the case for you guys to take a look at. We also have
he's a litigant. He's affected. He cares about the integrity of the court proceeding that he is engaged in, and it's critically important to him and his family in his view. And he believes that having open court enhances the integrity of that proceeding. Perplexed by how an individual whose life is at stake in this proceeding, or whose relations with his family are at stake, doesn't have standing to say it's not fair to me to close this courtroom.
Okay. We also have another one involving the Rupert Murdoch Family Trust. But the point I'm trying to make is that that's just divorces. Like, if you take a look at paternity cases or termination of parental rights, those cases are super sealed. I mean, you can't even pull up a docket. They hide the existence of the case entirely. One of the most amusing things about our efforts to get into the Rupert Murdoch case was when we asked about the case, and we got this really cryptic response from a clerk, where it was almost like she was saying, we cannot admit or deny that this case exists. It was ludicrous. Like, that's what we have. You would think that these cases involve some kind of national security or something. No, it's a family court case that's sealed so extensively that you're not even allowed to know that the case exists. Get your head around that. So, by the way, if the entire case is super sealed, if its whole existence is inaccessible, what does that mean for publication of videos? If all of the filings are confidential, if all of the videos are sealed, then that would basically mean that you can't even discuss a paternity case's existence. The existence of the case is sealed. So any discussion at all on that paternity case would, under, I guess, this bill, be confidential and punishable as a category C, whatever, D felony. It's still a felony. So we're going to go into the next document now to see what happened. This is another minute order, it looks like. Yes. This is from, it looks like District Court Judge Gloria Sanchez. I do not think that was a family court judge. She's not on the bench anymore. I'm pretty sure she's a non-family court judge. And let's see. Minute order on the hearing set for August 23rd and the ex parte motion to set aside by Judge Sanchez. This presiding judge and the family court administrator have met with Judge Nathan, as well as plaintiff's attorney, with respect to pending matters on Department T's calendar pertaining to plaintiff's attorney. As a result of these conferences, and in the interest of expeditious resolution, it has been determined and agreed that the video of the June 29, 2012 proceedings will not be reproduced, disseminated, or viewed by any third party and will be safely secured in plaintiff's counsel's office. Should defendant's attorney have a copy of these proceedings, this directive will apply to his office and staff as well. In addition, the pending hearing scheduled for August 23rd, 2012 is hereby vacated, and Mr. Scalia's ex parte motion to set aside the July 23rd, 2012 order and his ex parte motion to discharge, order to show cause are hereby deemed moot. So they came to some kind of deal in chambers, it would seem, or in an office somewhere. I don't know. This it says they met with the judge, but it doesn't. I don't see why the family court administrator would go into the courtroom on the record. It was probably in some conference room or an office or something. We don't know why the video is sealed. They still don't explain why. And what it appears is this is like some kind of agreement that Mr. Scalia will not be jailed, but he has agreed to not release the video. And so, I don't know, put yourself in that lawyer's shoes. You have a video that has nothing secret or nothing confidential regarding children or families, and I mean, you have the power to release it, but your license to practice law is on the line, and it would seem that you could potentially sit in a jail cell for who knows how long. This has an impact on free speech. I mean, this is abundantly clear. So I did promise that I was going to go into a lot more, and I do have a few more clips to show you guys. Here we have a clip involving another lawyer. This is an attorney from California, and this is an attorney who benefited from the legislature's wonderful statutes categorically sealing family court cases. Because of those statutes, we were not able to get access to this video until after the Falcone decision. In other words, had the Falcone decision not published, what you are about to see would have been confidential and sealed.
Please tell this hapless pro se litigant, I have sued more than 11 judges. I hold the record in the state of Nevada. When I say I'm going to sue somebody, I always sue them. I've had this problem before. Our Nevada judges, with whom Your Honor is presumably familiar, I would ask that the court identify this third party who is present. I want to get his name so I know who to file suit against.
Because once the statute makes the state part of the action, then they are allowed to file under Rule 11.
And you are violating my privacy. This is a sealed case, and you're knowingly allowing a third party to be present. Respectfully, sir, you are not doing that. You are violating my rights. And I'm putting Your Honor on notice of that in my intent to seek relief against the bench. I regret that it's come to this, but it's just a sad thing all around here.
Do the state want to respond to Mr. Phillips'?
No, I'd actually like to talk about the reason why we're here today.
Yeah.
And I've given my express intent to file a lawsuit against Your Honor, respectfully, and knowing we have this adversarial posture, I don't think Your Honor can rule right now. I've sued Judge Harder, Judge Ochoa, Duckworth, a couple of sordid hearing masters, Linda Marquis. I have 2 lawsuits coming up against Hoskin and Bell. I have no problem suing jurists.
All right. On the record, I have not 1 ounce of intimidation by T. Matthew Phillips, so I could care less that he knows who I am and my bar number. However, Your Honor, I think this is a travesty what's happened in the last 4 hearings. He's getting away with not being held accountable for child support. This is actually very pathetic.
And I think that word pathetic absolutely describes the situation. We have a lawyer in open court who's not paying child support, who is upset and indignant that his sealed case, this attorney has since been declared a vexatious litigant by District Court Judge Heidi Almasi. You guys can watch the entire playlist. The only reason this playlist is available is because of the Falcone decision. And it's very difficult for me to get my head around why that is confidential. We have an attorney who is completely out of control, threatening the judge, trying to control the judge, bragging about how many judges that he has sued. And we can't get access to that because apparently that's sensitive. And the other attorney who basically just has to suffer in silence because the case is sealed, no constitutional analysis whatsoever. That's the handiwork of this legislature and their approach of just categorically sealing whole swaths of cases. It's absolutely mind-boggling that the situation got this bad and nobody did anything about it. The legislature certainly didn't. We had to go over their head to the Supreme Court and have the statutes that they were using to shield this kind of misconduct struck down as unconstitutional. If it was not for the Supreme Court, I can't even give credit to the full Supreme Court. I mean, I'm not going to apologize about this, but the dissent, there are 3 justices who participated in the dissent. If they had it their way, this video would not be accessible either. In fact, under this legislation, if I would have put this video out, I could be targeted by T. Matthew Phillips. He could try to have me thrown in prison for putting that video out. Doesn't mention in his address his social security number, doesn't mention his birth date, doesn't mention his children. No. Again, guys, you could watch the playlist. I finally was able to get these videos thanks to the majority on the bench in the Supreme Court, because I honestly did not know it was this bad. I knew about some of the problems, and it wasn't until I actually got these videos and watched them that I had no clue. And that's perhaps what the intention of those statutes is. It's either the intention of the legislature to conceal misconduct and incompetence and whatever you want to call it. It's either the intention of the legislature to do this, to hide these things from the public, or it is not the intention of the legislature, which would mean that they are incompetent. They are not looking at the language of the statutes that they are putting together, and they are not considering the unintended consequences of their legislation. So either it's deliberate or it's just full-blown incompetence. It's hard for me to be nice when I see these egregious examples of misconduct in court that should not be sealed. It is not confidential. Okay, so the next clip, we have Mr. Willick basically singling out the Supreme Court of specifically Justice Ronald Paragary. The reason that this clip is important is because a lot of people have asked me, how on earth did this committee consider this a great idea? And what I have been telling people is that Mr. Willick is not apologetic about how he gets people to go along with what he wants as far as secrecy. He simply tells them, how would you feel if your case was public? And this is not this is known as a golden rule violation when you tell a jury. It's definitely not how you govern a society, because what it does is it basically invites bias, and it invites the person to put their self-interest ahead of the interests of our society. And the reason I'm about to run this clip is because people will think it's a conspiracy theory. When you see this clip, you will see that not only is Mr. Willick insinuating that decision makers, you should consider the fact that your case might be unsealed, he is insinuating it live on camera in the Supreme Court to a justice of the Supreme Court. That is how unapologetic he is about this approach. So let's take a look.
Assert that no one has a right to keep their own personal, private information private. They want Justice Paragary to say that you have no right to seal your divorce case.
Yeah, Justice Paragary. That's what this is about. This is we're going to do a discussion on the First Amendment of the Constitution, and I want you to consider that your divorce might get unsealed. By the way, Justice Ron Paragary was on the side of the dissent. In other words, he was not on the side of the First Amendment. I don't know if it is that Mr. Willick's argument here was persuasive, or if the justice disregarded it and made his decision based on other things. In fact, I will assume that the justice most likely did disregard Marshall Willick's suggestion here. But it certainly does not look good when Mr. Willick singles out this justice and his divorce case and suggests that his divorce case might be unsealed if the statute is struck down, and then for that justice to be on the side of the dissent. It certainly does not look good. All right, we're going to go into the next clip. This has to do, I'll just let it speak for itself.
So one of Willick's attorneys in his office is a sexual predator.
Yes.
Tell me a little bit about that.
Oh, Richard Crane. As far as I know, they've been partners for the longest time. Richard Crane is a Tier 2 registered sex offender. It's on the registry.
And he's a family law lawyer.
Yeah.
What did he do? What was his crime?
I believe it was Henderson PD that did a sting back in 2014, around there, I want to say. And it was an online thing where they're trying to catch sexual predators online talking to kids.
Mm-hmm.
And I guess Richard Crane believed he was talking to an underage minor. It was actually Henderson PD that he was talking to, and he got arrested. He got busted.
Mm-hmm.
Trying to pick up on an underage minor, trying to have sex with him. He got arrested, he got charged, and he lost his law license for a couple of years. However, even though he lost his law license, Willick was still allowing him to work in the Willick Law Group and still billing everything Richard Crane did. I mean, if you got pictures of kids, investigations, naked pictures or whatever, this guy's seeing all that. He's a registered sex offender.
My research shows that despite being removed from the profession, Rick Crane was still appearing in bills sent by Marshall Willick to his clients.
I heard that.
So it apparently this attorney was reinstated, and from what I recall, he is no longer on that registered sex offender list. I asked the government to respond and sort of explain how that happened. He's either not on the list or his sex offender status was reduced or something. The point I'm trying to make is we don't really know because we can't get a response. And I can guess that most likely it just timed out. That a lot of times there are sentences that are put in place that after a while the case is dismissed or it goes away, or there may be the requirement to register as a sex offender is gone. If I would have gotten a response from the government, I would definitely provide it to you guys. And I want to stress that Mr. Willick having this person working in his office, I don't think it's illegal. I don't think it's a violation of the rules of professional conduct. I really don't. The problem is that people might want to know that. And an even bigger problem is Mr. Willick is presenting himself as caring about the confidentiality of these cases. And I want you guys to understand, if cases are sealed, the attorney on your case still has access to those records. I don't know if Mr. Crane had access to sealed records or not. I would assume he did because he's working there, but I don't know. There's never been any kind of explanation as to the level of his involvement. But this is something that I have serious doubts that the committee was aware of. I think if the Judiciary Committee was aware of this, especially if the committee was aware that they were making filings confidential that this particular attorney would still have access to, it's difficult for me to get my head around the possibility that they knew and we're okay with this, and we're okay with Mr. Willick's presentation. And so really this is just, it isn't necessarily that Mr. Willick has violated any rules of professional conduct or criminal statutes or anything, so much as parents who hire him might want to be aware. They might want to know. And let's go ahead and move on. At this point, guys, I'm going to just go ahead and run the rest of the hearing from the first portion of the video. But if you guys get a chance, I submitted an op-ed to the Las Vegas Review-Journal with some more of my, opinions on this legislation. Do keep an eye out for it. I hope that the Review-Journal publishes the op-ed. And if they do, I'll go ahead and post it down in the comments when they do. But that all being said, I'm going to just go ahead and run through the rest of that hearing.
So we're getting back to the disgorgement of the fees, Your Honor. I think that, I understand that it's like baseball. No one can bat 100 all the time. But I think the facts of this case and the law of this case is argued. I've seen better defenses raised by the Pro Bono Project, really, Your Honor. And for them to come in here and argue $23,000 in fees under these facts and under this law, goes beyond the realm of ridiculous, well into the world, of absurd. Those fees should be disgorged, or at the very least, charged back to the American Express account. They should be paid on a quantum merit basis. I'm not saying that they shouldn't earn something. They should earn something. But then, and let's get to the counter motion, they did all of these motions, seizing all these accounts, which I would call that rookie mistake 101. An over-aggressive attorney right out of law school would start seizing bank accounts which had nothing to do with the parties. They made a big mess of this. I came in here personally to pick up the order to unfreeze the accounts. I had to do it on my day, and I called Mr. Willick, and I called the opposing counsel that day. Mr. Willick was in the meeting, never called me back, never did anything, had to stop what I was doing, because had the banks had those accounts freezed, Anderson Law Group could possibly maintain an action against the Willick Law Group downtown. But I did it, even though I called them numerous occasions. Now, I didn't do it out of charity. I did it for the well-being of my client, obviously, but it's something that they made this mess, and now they wish to withdraw from this mess that they created. So I'm going to oppose their motion to withdraw. I think that Brenda has had a drug problem, and until we're completely sure that she's completely rehabilitated, she has to have counsel, and they've been paid. And I would prefer that she have counsel and go forward, so that way we would have a problem later to say, oh, she wasn't represented. I oppose their motion to withdraw, and I think that some of the funds that they've earned so far should be disgorged on the facts of this case as they are before your honor today. I think that's what has to happen.
You want to start?
Sure. Basically, as far as the fees go, there should be no disgorgement. We've worked, we've earned the money. She signed a contract, said that she would pay her bill of hours. That's what she's done. As far as what he's just said about the order, that went around our office. I was out of town. Mr. Willick was not available. Someone from his office contacted our secretary and said, the order's ready, we picked it up. We had no idea why. Your law clerk had not even contacted us yet. So whatever he's done on that side of it, there has been a breakdown in communication with our office and our client. We cannot at this time continue to represent her, and unfortunately I can't divulge to the court what has been said, what hasn't been said, whatever. As far as the issue with the bank accounts, based on, I don't know if you've had the opportunity to read what we got filed for you yesterday, but there's documentation in the letter that was attached as an exhibit. There's also the way that they have been throughout the marriage with the way he's handled the money and always taken it out of those accounts from the businesses. That did have something. And then when he totally cut off all her access to any kind of funds, there is an issue with it, and we had asked for that in our initial motion. Didn't get heard, it got continued. We had no choice after he cut her off is when we went and worked that way. I don't really have anything else to add. Mr. Willick is going to add something about the fees, I believe.
Very briefly, Your Honor, and I don't wish to make a long record of it. There is no difference to how we litigate our cases, whether we're representing a client pro bono or on retainer. The statement that there should be is loathsome. I have been insulted in this courtroom. I have been assaulted in this courtroom. I asked not to be interrupted. I bit my tongue.
Please advise Mr. Willick to address the court and not counsel. I'm not the judge here. You're the judge here. He should address you, not me.
I am doing so, but I asked Mr. Scalia to sit down and shut up.
Your Honor, really, Mr. Willick, this is really completely unprofessional. This is...
Stop!
He's having an outburst.
Please.
Mr. Willick.
I want 5 minutes of uninterrupted time, then I will shut up and go away. I am not in the mood today for histrionics. I am not in the mood for personal attacks. I am not in the mood to be insulted. We seized nothing. A JPI was sent to bank accounts. It's all perfectly legitimate. The attachment of a piece of one of my legal notes claiming that the court has the authority to enforce a JPI, which of course is true, is stupid and irrelevant to the issues currently before the court, as is the filing of a motion complaining about ATM withdrawals by a person on vacation and normally scheduled hair maintenance. We understand that's more of a concern for some people than others, but it's a perfectly legitimate expense. There was no harm, no foul. This motion should have never been filed. It was taken care of at the last proceeding. It is a transparent effort to waste money, consume the funds currently sitting in our retainer account because the guy sitting at the other table has all the money. The only thing he's pissed off about is that she managed to get some of it before he managed to cut her off by using the credit cards. There has never been a motion, certainly not an order, certainly not an opinion in the state of Nevada where the moneyed spouse asked for disgorgement or, God help us, sergeant equalization from the non-moneyed unemployed spouse. The whole premise of the motion is beyond stupid. It should have never been filed. The court could sua sponte issue sanctions for filing that pile of crap. In the meantime, because of our communication difficulty with our own client, and because we are forced, because of an internal matter relating to our office and our contract with our client, to withdraw, we ask the court to permit the withdrawal. If you want to space it out until after our client is released so that we can communicate with her and allow her time to get new counsel, that would be fine too. In the meantime, the funds sitting in our retainer account, and I don't have I don't have an accounting, but I will be putting.
All right, we're going to go off the record for a minute. Counsel, can I see